Now let's come together for our next session, which is on the theme Anatomy of a Portfolio, a new approach to managing your IP assets. We'll cover IP diligence, risk analysis, emerging technologies like 5G and 6G, patent protection strategies, licensing models, portfolio management, filing schemes, and balancing trade secrets with patent in a competitive market. Now let me begin with introducing our moderator, Mr. Ramesh Kumar Verma from Tata Chemicals Limited. As the manager of IPR since 2008, he leads Tata Chemicals IPR team, a registered patent agent with a postgraduate diploma in patent law from Nalsa University. His expertise spans IP strategy, innovation, and patent prosecution. Welcome, sir. Joining him, we have an exceptional lineup of speakers who brings diverse expertise to the table. Now, first, I'd like to invite Mr. Tuhin Subra Singaroy from Avery Dennison Corporation. As Intellectual Property Counsel and Patent COE Manager, he specializes in IP procurement, portfolio optimization, and integrating emerging technologies like AI into IP strategies to enhance product development. Welcome, sir. Next, we have Ms. Pranita K. Rasbag from Prasa IP with over 15 years of experience in international patent law. She collaborates with R&D team to develop strategic IP roadmaps, conducts training sessions, and is a recognized speaker in IP community. Welcome, ma'am. Joining us next is Dr. Shamim Ahmad from Origin Oncology Limited. With over 16 years of experience in the pharmaceutical and biotech sectors, he excels in global patent strategies, monetization, and high-value licensing agreement. Welcome, sir. And lastly, we have Ms. Ashima Katara from Unilever, a registered patent agent with research experience in neurology. She blends legal and technical expertise to provide invaluable insights into IP management. Welcome, ma'am. With that, I would hand over the session to Mr. Ramesh Kumar Verma. Thank you.
Thank you. So I welcome you all for the 14th technical session of a portfolio, a new approach to managing your IP assets. And I welcome my fellow panel member. So to start with, I'll start with asking my fellow panel member to introduce themselves. But before that, I would request them if they can cover what do they mean by the IP portfolio? If they can elaborate with their respective technology domain, then on this topic. So I'll start with the Asima first.
Hi everyone. So today we are talking about IP portfolio management, and as IP states, it's not just patents or designs or any one of the intellectual property assets, but it's about all of them. And it is about strategy administration of managing the IP core intellectual assets of companies, which includes all patents, designs, trademarks, trade dress, copyrights, and whatever comes under IP assets. So that's all about managing these assets, and there has to be a holistic approach to managing these assets, such as we cannot just say that patent filing takes care of all of the IP portfolio of a company. It has to go hand in hand with other aspects such as designs, trademark, and we very well know, being IP professionals, that there are laws which prevent overlap, like in Copyright Act, like in Designs Act, that you cannot protect all of them side by side. However, you also need protection when you launch a product in the market, whether it is protected from all angles, like for technology, patents are filed, aesthetics are protected by designs, copyrights are taken into account. So all of these go hand in hand, whether the logo is protected by trademark and the overall trade dress of the product. And we see this as a very good example is Apple. So Apple has many patents which protect its technology. The design protects the aesthetics of its products and services. Copyrights protects the algorithms and program applications, and trademark the logo and all. So I think that's a very good example. And similarly, company like mine, which is Hindustan Unilever, and all of these are taken into account when we look at a launch of a product.
Thank you. So I will request next to Mr. Samim Ahmed.
Hi everyone, thank you very much. My name is Shamim and I come from a company named Origin Oncology. As their name suggests, so Origin is working in developing new drug for cancer treatment. And so when it comes to a patent portfolio for a drug which is being invented from scratch, so I think it's very different from other technology, because in many of the domain, the life of the product is very short. So by the time the patent comes or granted, your product will become irrelevant. Whereas in case of medicine, by the time your product comes, you already have eaten out half of your patent life. So it's a very contrast. So you have to do a lot of balance. At the same time, it is very important because the amount of investment required in developing a drug is extremely high. It's very, very high. As of now, it says developing a new drug from scratch, it costs around $2 billion, roughly. And the failure rate is damn high. It doesn't make business sense, because 8 out of 10 drugs are going to fail. As of now, in clinical trials, 8 out of 10 drugs are likely to fail. The cost is high, chances of failure is very high, plus the amount of time it requires about 10 to 15 years to develop a drug. So you add all those things, it looks like it's a very bad business plan. So, and since you are investing a lot, so you have to ensure that how to protect that. So I will just in just a previous session, I just hearing that how to build a patent portfolio. So I think the Professor Anindya Sirkar had mentioned about 3 things, and that rightly applies to any biotech portfolio. So you have to build a portfolio around your defensive. Something should be a patent which is going to monetize, and certain patents are going to be a strategic. So it's very important to ensure that you have a patent which is well secured and which is going to give you the actual patent is going to sustain any litigation, because in pharma, the good or bad part is your patent is most likely is going to get litigated once you are successful. So you have to make sure that you have a patent which you can count on, and that covers your molecule. That's your base patent, which you are going to rely kind of dependent on monetization. And during the course of that, you have to manage a life cycle, because the managing a life cycle becomes very important, because as we discussed, a lot of time goes taken out in the development phase, because it takes almost a decade of patents. The life of patent is 20 years, so more than 10, 15, 12 years is already gone. So you have to build a patent portfolio, so the one which can really stand and can give you a return. So that's important. And then the strategic patent filing. So the patent which you can use it in long run, maybe for licensing and ensuring that you are protected. And so it's kind of, it's long game, it's keep on going. So maybe I'll just pause here because others have to speak. Thank you.
Thank you, Mr. Samim. I'd request Parinita to introduce herself and talk about.
Thank you, Ramesh. And good afternoon, everyone. This is Pranita from Prasa IP. Today, I'll be talking more about from the perspective of the startups and the educational institutions. Of course, my co-panelists will be covering towards the multinational companies. To us, as IP professionals, an IP portfolio is a value-added assets to any kind of entities, may it be educational institutions, startups, or bigger organizations. It's the collection of value-added assets which drive the businesses towards success. So this is the key for any organization, to have that kind of an assets which will add value to your business goals, which will align with your business goals, and ultimately yield revenue and other kind of successes to the businesses. So this is extremely important for all of us to keep in mind as to how do we start from the scratch and not in the middle of your business, to make sure you yield that kind of an assets which will ultimately yield you always fruits out of it. So that's how I would like to put out on how you have your IP portfolio and what could be the new approaches that will that has to follow. Over to Tuhin.
So thank you, Parinita. I'll request Mr. Tuhin to.
Thank you. So I think the way one would start about defining IP portfolio is that IP portfolio is a collection of related IPs of different nature, owned and controlled by a single organization. And when you talk about portfolio is different from a single individual and scattered patent. So to maximize the value from your IP filings or any other form of IP assets that we discussed, other panel members discussed, so you need to create and have a portfolio approach. And the origin of portfolio approach comes from your business strategy. So the first question that comes to my mind is that IP department and councils can ask us R&Ds and business group is, what is the expectation from the IP? What is the business goal that can be advanced by the IP tools? So here the conversation from promise to performance takes place. So single IPs often is kind of a promise, but that promise may not reflect into performance. If you want to create a situation for that promise to perform, you need to create IP portfolios. So now, if you go back down to the lowest denominator, single individual patents, what is the single individual patents that brings values to you? What kind of value that you would look at? If you just talk about in legal sense, there are three top kind of evaluation that you make: the validity, scope, and discoverability of infringement. So are you writing patents which are going to be enforceable, which is going to be valid in the court of law? Because you have to back calculate what is the infringement scenario. It is likely that your patent going to be infringed. So we do not write patent just for not infringement. We write patent to invite infringement to happen so that I enhance the value of my patent. So that's validity. Second is scope. What is the scope? What kind of technology your patent covers? What kind of competitors? What kind of product? What kind of geography? And then discoverability. So the first scope, validity and discoverability are the gateway questions. In terms of, if you lose on validity, if you lose on discoverability, you lose the entire value from your single patents. I'll come back to the portfolio dimension a little later. So what is discoverability? You write a claims, you rely on parameters which are possibly very difficult to establish, because you as a plaintiff, you have to go and prove in the court of law that someone is infringing. The burden is on you. So you have to understand what are the parameters that is easier for you to prove the infringement. So now, if you look at the portfolio side, it is difficult to maintain and create portfolio unless the business goals and strategies are completely fully baked. A lot of business areas, both in the startups and younger companies and big companies, happens that some business areas, the strategies are not fully grown. It is still evolving, but still you need to have some ideas and questions asked as to what is the expectation from the portfolio. What kind of patents you are allowed to file compared to the position of the market and business dynamics. Broad patent possible, technology lifecycle, SCAP, narrow patent. What is the objective of the portfolio? You are going to use that only as an exclusive property of the patents. That means that you are going to block for someone else to enter, or you are going to also create some kind of licensings, collaboration, because many areas are growing. For example, in manufacturing, electronics, the nature of the technology is like sequential invention and complementary inventions. No one can design all the elements that are required to create a product. You need to collaborate. So you need to keep open that space, that you are not just developing your portfolio for your own use. You need to make and ensure that someone else can also use and collaborate and further develop the technology. How you organize the portfolio. Is there a chance of licensing? So these are the all different aspects that can come when we talk about portfolio. So I will stop here and then move to the other part.
So thank you, Mr. Tuhin, and thank you all the panel members for their opening remarks. So, and Mr. Tuhin has gone in much detail about how to create a portfolio for IP. And in that sense, I would ask my question to Mr. Sameem that what about risk analysis? Tuhin talked about creating a winning portfolio which can give you the real value, but is there any risk creating the just portfolio, and how do you mitigate that? What are the other considerations you take care? Is there any budget constraints comes in the picture?
Sure. When you say talk about risk analysis, so there is a long question of due diligence. When you are building a portfolio, you have to make sure that you are doing a proper due diligence. And it becomes very important when your product is going to get launched after many years, especially when it's going to launch after a decade. So you have to do your assessment right away. You can't wait to do those assessments after 10 years. So risk assessments, or I should say the due diligence should start at the very beginning, and you have to start keeping things right. So there are long checklist, maybe 1 or 2 points I will capture. And the first and foremost important is the title. If you have a patent portfolio, let's say you have a basic patent which you are relying on, or you are thinking this is going to get monetized, do you have a right title? That's the first thing. The title starts with inventorship. Do you have the right inventor? Especially when in the world where you collaborate a lot, where you collaborate with the maybe US institute or or maybe other companies. So how do you ensure that you have a proper identified proper inventorship and you get the things right? For example, I could just quote one case which is a very high profile case, which is a drug named pembrolizumab, Keytruda. So that is a PD-1, PD-L1 modulator drug. And a case emerges. I think the good part is, or bad part is, that nobody is going to bother about the patents unless you are successful. And that's how it happened in pharma and biotech. The moment you start seeing the success, then people are going to find out the loopholes. So there, I think that the invention started with the Japan, the Keytruda University, where the Professor Honjo, one of the Nobel laureates, and he was collaborating with the US institute. And the Keytruda University, the Koita University, they filed the patents. They did licenses to Ono Pharma. And since they were working in collaborations, they filed a patent after breaking the collaborations. And they just named the inventor just from their team, did not acknowledge the contribution from the US part. Much later, many years later on, when they identified, then started going back and digging down, and they identified the inventor, the two inventors were not named. And because of that, they filed the case and they won the case, and they went for the outside settlement, and that there's undisclosed amount. People say there are more than $500 million settlement amounts just to correct that title, and they had to settle a lot of litigations. So you have to ensure that your inventorship is right, your title is right. And once that is done, then ensure that you are applying, because in pharma and biotech, you file patent in many countries. You are not developing a drug for one country. So while you are doing that, make sure that certain basic things, for example, a foreign filing license, looks very silly things, but I have seen cases where people have missed it and they are in trouble. So make sure that all those things, looks small things, make sure that those things are right. Thank you.
So thank you, Mr. Sameem. So I'll request Ms. Asima, if DC can give her
I'd just like to
views
add
on
to this about risk analysis as freedom to operate as well. And one of the mistakes that many innovator companies even do is like they're too busy in filing patents, protecting IP, but attention also needs to be paid on the risk analysis. And many of even we face this many a times from our R&D colleagues saying, but we have a patent for this. So it is a misnomer and misunderstanding to think that if I have a patent on this, then the risk is already mitigated. It's not there, but it's not correct. And it needs to be taken into account that even if I have a patent on this technology, I need to see what is out there, because having a patent doesn't mean that the risk to be infringed is low. So that's the point I wanted to.
Thank you, Ms. Asima. So I'm taking liberty here to ask multiple questions to the same person, because the person is going to leave. He has a flight to catch and he's going to leave early. So my next question to Mr. Sameem, that so you talked about that risk thing, doing a due diligence, and but a lot of time companies file patents, and some people say they have a strategy around filing a patent, and some people say that they have filed a patents and let's make a strategy what they can do. So what is your practice, what is your experience about that? Whether file first, then make a strategy, or you have a patent portfolio and identify, first you build a number, build a case, build assets, then you find out the strategy, what you can do with those assets. At the end of the day, IP is an intangible asset.
Yeah, that's a very good point. So in general, a strategy first, file later. That's how it happened in general. You don't rush for patent filing. You have a proper strategy, develop something, see that it's working, because you are not rushing to launch a product, especially in biotech. Launch is going to happen a lot later. So there's no rush for patent filing, but yes, there are certain situations where you have to rush for patent filing when the space is very crowded, it's competitive space. At that point of time, you have to think about filing first. I will give you an example where, especially in a biotech, maybe it started happening last maybe 1.5 years or 2 years, where with the advent of AI, and I'm seeing the China is coming up with the very aggressively in the drug discovery phase, where unlike earlier, where we used to see patents coming from US and Europe, last 2 years, I started seeing a lot of patents on maybe a novel technology, novel drug discovery started coming from China. A new target is identified. When I say target, it's protein targets. A new biological target is identified in some high-profile journal. And before you think of doing something, you start seeing a patent coming from China. And it's kind of, you are scoped off, because you are thinking, I will file a patent, aram se, there's no rush. So then, in those situations, when something comes which looks very promising, you don't want to wait to lose. Rather, you file first and then think with how it is working. At least you secure a date. So
Thank you, Mr. Sameem. So I'll request Ms. Pranita if she can give her perspective from the academic.
Absolutely. So I think I always have, in the initial stage itself, I give an opinion that we need to align IP goals with business goals, have a strategy first, and then, go about your IP strategies after, go about filing your IPs in general. Of course, I do not want to just talk about patents, and of course we have, as Asima pointed out, we have other forms of, IP rights like copyright, trademark, designs, and so on. We, as an organization, when we are planning out things, when we are filing or investing money, we need to be careful about what is this technical, R&D which is going on, and what kind of strategies needs to be developed for that kind of technology. For example, you may have legacy products which are out there since years, right, where the development is, happening at a slow pace, and then you have a breakthrough inventions which are coming up with new technologies. So in an organization, there are gonna be these such kind of products which are legacy products, which are new products out in the market, and that's where I think we have the due diligence playing a role. We have something of landscape studies or state-of-the-art studies which will help, building a very strong IP portfolio in that regard. So without strategizing these things or taking consideration of, what is the technology that I'm developing, what is the market out there for this kind of a technology, how aggressively I need to file patents or trademarks or copyrights in this regard, or is it like, something I have to take a back and then just file a technical paper over it because it's something which is very trivial to go about, or just as a publication, as a defense, or should I keep it as a trade secret? So it all depends upon, without strategizing, it's very difficult to go about a direction in an organization, because the strategies may differ from each technology. today we are coming up with a lot of technologies related to Gen AIs or LLM models, or we may have, for example, related to 6Gs or EVs, right? So these kind of technologies are upcoming technologies, and we need strategies which are very aggressive in nature. And this also determines about, where is your business? For example, you have a very strong business in particular jurisdictions. It truly matters on what kind of competitors you have, and you need to really bridge the gap between your organizations from the top level to the lower level. Like your sales team needs to be aware. You need to know the value of counterfeiting, brand protection, and what you need to do at that particular level in a company policy. And this really affects if you're not having any kind of strategies in place, because I know my product is there, and I know this is what is the technology over there. And if I keep on filing patents without having a strategy, knowing which countries I need to file, or which, what kind of market study has been conducted, becomes very, crucial for the companies to build a very strong value-added IP portfolio is what I would say.
So thank you, Pranita. So I'll add little more in that to the question, not to the answer, for my next two fellow panelists. So you have products which have been from decades there. Still your R&D is continuing in that. So your initial IP strategy was there, and so now if you have to talk about whether your IP, whatever you say, invent first, then strategize, or for make a strategy, then invent, then that. So what is your opinion on about the existing products? What is your... So I would like to thank you, Mr. Samim Ahmed, because he has to catch a flight, so he's going to take a leave on that. So I thank him. So thank you, Mr. Samim.
Thank you, sir. Thank you so much, sir, for your contribution. Thank you, sir.
I would always start from the business conversation, and then the input that comes from the business to the R&D and different commercial groups. So let's say what the scenario that you just mentioned is that one portfolio is a little old. So what is the impact of that portfolio from the commercial perspective? So is it that you have started losing market share? Is it that you have started losing your margin? Margin erosion has started happening. You also start seeing that there are a lot of competitions that is taking place. So what you do, is it that there is technical opportunity left, or it is like some kind of relationship, real establishment of the relationship through trademark or branding or market communications? Different tools are available. So as portfolio perspective, as you talk at the portfolio perspective, there are multiple individual related IP assets that reinforces each other. So patent reinforces trademark, trademark reinforces patents, and the patents are not a uniform term. There are multiple different types of patents and different age of patents. So at an advanced level, we would know which patents go off and how it is going to imply with the market and revenue that I'm generating, and what are the second generation patents that are going to take care of that. So that conversation takes place in that directions. And one scenario that might happen is some emerging technologies. So emerging technologies, most of the time it is guess. We do not know what is the point of pivot for me, how much patent needs to be filed, because that's always a guesswork. But what I think is that what is the capability of your R&D that aligned with the business perspective, the way you are perceived in the market for your customers. So if there is technological opportunities and that can be covered under patents, so you do file the patent first and try to see that what happens. You might revisit that situation and tweak your strategy differently. So that's, I think, I would recommend.
Thank you, Mr. I'll request if Ms. Asma, if she can share her opinion on this topic.
Strategizing, yeah. So I think
So why I'm asking this question, because when you talk about R&D and IP, so in companies you have existing product line which is coming from the decades, and still you have a team who is working behind those products, solving problems, coming up with new ideas, new solutions so that the product is ready for the future as well. And same time, because you have new programs coming on where you have as an IP team, you are putting a lot of focus and efforts to making strategy for them. So sometimes those IP R&D generated there, R&D work, IP generated there for the old products takes a back seats. So how do companies make the strategy around that, and how do leverage that IP for those old products?
So before I start with strategy for IP, I would say that all of us, whether we are from law firm or from an MNC or a company, what is the key goal? The key goal is working for a company, and what is goal of a company is to make business. So business is at the very heart of it, and all of us are working towards that, and it will be counterintuitive to say that IP strategy is not aligned to the business goals. So I think that's the crux, the root of strategizing is whether IP is aligned to the business goal of the company. So that's at the heart of it, and then from there we move on that whether my IP strategy is aligned to the business goal of the company. Like for example, startups, it may be different. It may be just to create IP to showcase, whereas for some of the well-established innovator companies, it would be to protect their R&D innovations. Similarly, different goals may lead to different kind of strategies for a company, and that is how strategies will differ. So that's how, and again, like the kind of space you are entering, whether you are the leader, like it's a breakthrough technology, then you would try to ring fence it very broadly and file firstly broad patents covering a lot of space, and then maybe as the technology develops to decide which areas to fill in more. And the broad patents would kind of ring fence, create a fortress without leaving gaps, and that's what the strategy would be. Whereas the strategy would differ if the technology is in a crowded space, then you would like to fill up the gaps in that crowded space. Similarly, strategy would differ if the technology is fast-paced, like if the technology only lives for 2 years, suppose it's more of a digital technology or software, then maybe you think that some other product down the line will come and take its space in next 2 years, then would you really want to protect it through patents? Maybe in countries where utility models are allowed, you'd want to go into a utility model, file utility model. Similarly, whether design filing will serve my purpose better, whether I protect the aesthetics, and whereas patents would take longer to be granted, and design filing would be enough. So all of these things, and also where all do I decide my filing? What are the filing schemes is also part of strategizing. Which countries my business is present in, which are the developing technology areas geographically for that technology, then where my competitors may be present. Maybe my business is not there, but my competitors are selling, and I don't want them to take over my technology in those areas, even where I am not doing business in. So all of these, and patent prosecution highways, maybe I want to go especially in those countries where my patent is getting granted fast. So all of these and many more would be things to look in from strategy point of view.
So thank you, Ms. Asima. So my next question is, so how do you approach for patent protection in a crowded space? So I'll request Mr. Tuhin to start with his initial comment.
So we really need to understand that out of different tools that are available in IP regime, patent, trademark, trade secret, copyright, design. So what is most suitable to drive the value in a space which is extremely crowded? So if it is possible that you can apply patent, but you do not know whether that patent would be able to block others. If the objective is to block others, there could be other objectives. I'm not excluding that. or you see that a trade secret and you have internal mechanism to keep that information secret, or different set of information that you are using to create that offering to keep it at trade secret. Sometimes it so happen that there would be some sweet spots, particularly material science and chemistry, that you get to that specific point of different ingredient and you get a very surprising outcome and performance. So you can get a patent on that point. And then research, the way the research happens is that sometimes some of the product development would be designed to value. You want to generate value. You don't really concern about the cost of development and putting that product in the market. And sometimes just opposite to it's the design to cost. So where the cost is most important. And accordingly, you could roam around the spectrum. Which kind of IP would be useful for you? It may also happen that you are developing the product, working with some end users or suppliers. So you need to utilize the contractual obligation, contractual relationship with the ecosystem that you are co-creating and bringing that value for your customer. So different types of collaboration agreement and exclusivity, be it market related, product related, users related exclusivity, that can also be exploited. So this is how I think in a crowded area where technology is almost saturated, you can still exploit and leverage some kind of exclusivity and to deter others.
Ms. Asmi, do you have any point to add in this, or you have any?
So I just mentioned that in a crowded space, then you would see where you want to position yourself, because not every space is available to you. Do you want to combine ingredients and fill in those gaps? So I think that's the best, and maybe file a larger number of patents. It may sound counterintuitive, but there will be small spaces which you won't be able to cover up in one patent. So small and many patents would be the answer.
So for that, do you, your quality matters over there, or it's quantity only matters?
I think quality is always important, because without quality, just filing a patent, I often tell my business partners in R&D, it's not difficult to file a patent. Anyone can file a patent. In a day also you can file a patent, but what it protects is important. If we are, and sometimes, it's a paradox that sometimes you feel that, it gets easily granted. Right? A patent gets very easily granted. That's not the sign that it's a good patent. Maybe you are not bothering anyone. No one is opposing. And but it's too narrow that no one is affected by it also. So getting a patent granted is also not a good sign that a patent is covering.
I would like to just add to that point, because when we say crowded space, that's very much applicable to AI or software related inventions, because what's happening is now AI is pretty old. I mean, you have very, thousands of patents, covering the AI, and AI is evolving. We have new kinds of AI which is in the picture, like explainable AI or, Gen AI, LLM models, and so on. So when we try to look into a IP strategy or an IP portfolio for such kind of products which are relating to the software related inventions, it becomes very crucial to understand what is the technical advantage the product is bringing into the market. Because a lot of times what happens is, of course, we all know about the chat GPTs or any kind of open AI tools which are available in the market. So when you really have to pitch in and put in your money, effort, investment into such kind of software tools, building software tools, or such kind of innovations, it becomes very crucial to understand what is that technical differentiator that you are bringing into the table in such crowded space. And this really matters in the whole life cycle of your patents. Because, for example, if you have not done FTO, I just want to touch upon the life cycle of the IP which goes in. If you have not done a freedom to operate search before getting into the market, you'll be under a huge risk, right? And B, for example, even though you might have new features which is covering in your software product, but you did not do a correct patentability search to understand where do you have to emphasize your patent claims, in how much broad can you go to, write, how much narrow have to write, what kind of disclaimers or boilerplates that we call is required to get into that kind of space, and understand the nuances of what could be overlapping during the life cycle, during the patent prosecution for that matter, really is important, especially in these crowded spaces, because it could be a small parameter change or the input which goes into your software models, or it could be the way you're utilizing the AI algorithms, which kind of AI algorithms is bringing a technical advantage over the other generic AI algorithms for that matter, really concerns. So it's very important for us to understand, if I have developed a product, what is the kind of compliances that I need to follow from the perspective of the IP, and to make sure that whether it's very trivial that I just publish it as a paper, or is it something which is not detectable if some infringer copies it, which is running at the back end, it's very difficult for you to detect, I keep it as a trade secret, or it's very crucial for the business and I want to patent it. So these kind of decision makings matters a lot in such kind of strategies. So I would say, to touch upon from the crowded space, the quality comes, when we say that I'm going to go in a patent application or a trademark application and align it with the kind of subject matter that it has dealt with, the value the product is bringing into the market, and at which stage it is in the market, like crowded space or is it new. So that really matters a lot.
So thank you. So my last question, so any thought about pruning up the IP portfolio? Because what happens, we keep filing, we have a strategy, but after a point we see that because all IP doesn't come free. It has a cost associated to it.
So if we just have a look at what is strategy in a very plain language, strategy is your unique way of creating sustainable business values. And it shouldn't be copyable or replicable, and it should not depend upon some of the depletable parameters that you have used to create those strategies. So now compare your portfolio. What are the parameters that going depleted? And you understand then from that point of view, you would not be able to generate the market advantage that you have, be it on the growth, be it on the value, be it on the understanding to keep your competitor off balance, maybe on the price point, maybe on the performance point, or you're not helping the industry to grow the technology domain where you have a stake. So in that case, you need to kill that and replenish that with the alternative technologies and alternative strategies to create and sustain those values that you are deriving in the business portfolio.
Thank you. Asima, do you have any point to add in this?
Yeah, so I think pruning is one of the key aspects of managing a patent portfolio. Just like as important it is to create new protection via patents, it is equally important to prune, because every now and then you need to see whether my portfolio still aligns with the goal of company. One is that, and other is for budget related issues. Everyone has a fixed budget, so to have place for filing more patents to protect newer innovations, one has to let go of older ones, and then they may not be still technologically still valid in the market, like the technology moves very fast and they may no longer be of that much value as much as newer patents are required. So closing on that end.
So thank you. Now because we have very limited time, so I'll open the floor for questions for the audience. So if anyone has any questions, you can ask to our fellow panelists.
Thank you. That was a very interesting session. As a practice and as IP professionals, we spend a lot of time with our R&D teams. But what's the take of the panel on spending some more time with our marketing teams and field sales? Thank you.
Absolutely. I think IP, sometimes we feel that IP is everything. We seriously need a relook at that may not be the situation. IP is a support functions which is kind of an ingredient for different other processes that happens in a corporate, and how you mix, how much of you mix, where do you support, where do you take the proactive stage and create that strategic roadmap to be built and the expectation to be fulfilled at the end of the business evaluations.
I think that's also very important when you bring in the kind of policies, regulations, or compliances the organization needs to follow. Because what happens quite a time, what we have seen is also during the sales, demonstrations to your customers, or even in a case where you hire an intern, for example, they just stay for temporarily within 2 to 3 months in an organization, and they are accessible to all of your confidential data, right? So if we do not make them aware of the consequences that is going to occur. For example, you go put a demonstration and, it's easily, you may not have so much of data on the technical backend, but then at least, if something goes out and you cannot file a patent protection for it, of course there's a grace period, but then it is also a threat to your own organization. So making them aware, bringing in the kind of policies and regulations will definitely help streamline this process. And they need to have quality gates, a checklist. If they are a developer or product life cycle management should have these kind of gates to ensure that they are meeting these compliances at the right stage of the businesses to ensure the entire life cycle is smooth enough. I hope that answers.
So just to say that for an IP practitioner, there are two aspects. One thing, you need to create IP, generate IP. So that's going to come from your scientist. But when you talk about strategy, markets, and budget, because you need there your business people are going to be on the driver.
I think all IP professionals should have a business acumen to them, because at heart, because we come from technology background, we are more bent towards R&D and technology, but business acumen is very important, I think.
So with this, I would like to thank my fellow panelists where they touched upon about pharma thing, where they talked about how much investment goes for creating a molecule and what is the success rate about a pharma drug. And same time, Mr. Tuhin talked about that how to create a IP strategy, which is not only just protecting your IP, but also creating an IP which invites other to infringe upon as an aggressive strategy. Ms. Asima talked about multiple IP. It's not only just a patent which is going to help you. So for in long run, it's your designs, your trademarks, your brands, your copyrights also. And Ms. Parinita talked about that importance for startups and academia, and about understanding the various scenarios which is going to helpful for that due diligence, how is going to play the role. So with this, I would like to thank my panelists and also to all the audience for being such a wonderful listener. Thank you.
Well, what an amazing session that was. Can we have a round of applause for all our panelists? And it will be my honor to welcome our moderator, Mr. Ramesh Kumar Verma, to kindly felicitate our respected speakers. First, we have Mr. Tuhin Subra Singaroy from Avery Dennison Corporation. Next, we welcome Ms. Pranita K. Rasbag from Prasa IP. Lastly, I'll welcome Ms. Ashima Katara from Unilever. I'd request all the panelists to come together for one group photo.